I am Priya Gupta from Lakshmi Legal Academy. Today we are going to deal with the topic of regional protection of human rights. We have three regional centers. One is in Europe, other is in America, third is in Africa, which is dealing with the regional protection. At Europe level, we have two organizations, or we can say two charters. Number one is the European Social Charter. It was established in the year 1961, that is, it is made in the year 1961. It deals with the economic, social and cultural rights. And the other organization, other thing we have is the European Convention. European Convention incorporates the various civil and political rights which are enshrined in UDHR. All the members of the Council of Europe are the members of European Convention, and it came into force on 3rd September 1953. It has 11 protocols. The basic object of European Convention is again to enrich and to strengthen human rights. That is why it imposed binding commitments on the state parties to enforce and to secure to everyone the rights and the obligations which are enlisted in the convention. For the implementation of this very thing, that is for strengthening human rights, till the 1st November 1988, we have two forms of organization. One is the European Commission on Human Rights, other is the European Committee. The first one, European Commission of Human Rights, which was in existence till 1st November 1988, was the principal organ which entertained the complaints which were relating or which were filed under the convention. The various methods by which it was working was that it was entertaining any petition from any state party which is alleging the breach or the violation of the European Convention by the other state party, or even the individual and groups and NGOs can also file a petition under this section. This matter to it was referred by the Secretary General of the Council of Europe. Then it starts a various process. Like it worked with negotiation and sort out the matter. Let us suppose there is a failure report, in this case, European Commission of Human Rights. Only then the matter is referred to as to European Committee. So, European Committee works only if there is a failure report by European Commission. This committee of Ministers of Council of Europe, it used to dispose of the matter only once if there is a failure report by the first organization. Everything, that is the European Commission and that is the European Committee, it was abolished by Protocol 11. Now, presently we have only one form of organization which is known as European Court. This European Court was set up at Strasbourg in 1959. Its jurisdiction is compulsory only for those states who has accepted its organization or who has accepted its jurisdiction for a particular case. The decision of the European Court is binding and generally accepted by parties to the case. It has rendered various signal decisions, we can say, for enriching human rights. Example, Lawless case, De Backer case. In De Backer case, even the Belgium constitution was to change because there was alleged violation of human rights in the constitution itself. Now coming on to the other part, that is the regional center at Europe, at America. In US, we have American Convention on Human Rights 1969. It was adopted at San Jose, Costa Rica in 1969 and it came into force in 1978. It incorporates only civil and political rights. It does not have anything for social and economic, social and cultural rights. It is only dealing with civil and political rights. The membership is limited to OAS members, that is Organization of American States. For implementing its provision, for implementing the provisions of the convention, we have again the two forms of organizations. One is the Inter-American Commission on Human Rights, other is the Inter-American Court of Human Rights. In case of Inter-American Commission on Human Rights, it may receive any complaint from any NGO person and it also deals with interstate decisions and it attempts to secure a friendly settlement. Then we come to the American Court of Human Rights. It has both the types of jurisdiction. One is the contentious, other is the advisory jurisdiction. However, the contentious jurisdiction is open to individual and state parties. This is the second part of regional protection to human rights. Now we are coming to the third part of protection to human rights, which is African Charter on Human Rights and People Rights Act 1981, also known as Banjul Charter. This is a very famous document, since it is the first document which is dealing with third generation right. Third generation right herein includes right to self-determination, right to natural resources, one's right to dispose of his wealth. So it is the only instrument also known as Banjul Charter which is dealing with third generation rights. And it also incorporates the various duties of the individual and provides a compulsory system of state petition. There is one very pertinent difference. In case of Banjul Charter, it is that for its enforcement, it does not have a judicial organ. It only have a commission known as African Commission on Human Rights, on Human and People's Rights, which is dealing with the functioning of this. Thank you very much. This was all about regional protection of human rights. I am Priya Gupta from
हो गया मैंने